Welcome to today's discussion. The topic of today's discussion is on constituent elements of crime. The fundamental principle of penal liability is contained in the maxim, actus non facit reum nisi mens sit rea, means that an act does not amount to a crime, unless done with a guilty intention. The two essential conditions of criminal liability are 1. Actus reus, 2. Mens rea. Let's see what actus reus is. Actus reus means the result of human conduct. An act is 1. Any event which is subject to the control of human will. 2. A conscious movement. 3. The conduct which results from the operation of will. 4. The result of human conduct which the law seeks to prevent. That is, if any human conduct, actus, is not prohibited by law, the act or conduct will not be termed as a crime. Hence, person who commits such an act will not be liable for a crime. It is also to be noted that any movement of the body which is not a consequence of the determination of the will is not an act. Thus involuntary actions will not become criminal act. Actus reus may be negative or positive. X shoots Y and kills him is an example for a positive actus reus. The mother of a child does not feed the child and causes the death of the child by putting it in starvation. Thus, actus reus in here is omission to act. The actus reus is negative. Let's understand the concept of mens rea. A prohibited act will become a crime when it is accompanied by a certain state of mind. There must be a mind at fault before any crime can be committed. An act or omission alone is not sufficient to constitute a crime. The act or omission should have followed by an evil intent. Hence, a crime equals a prohibited act or omission plus guilty mind. An act done with guilty mind makes it a crime, if the act is prohibited by law. Mens rea is an evil intention or knowledge of the wrongfulness of the act. Mens rea may be of different kinds. 1. Intention. Intention indicates the state of mind of a man who, not only foresees, but also desires the possible consequence of his conduct. The intention is the deliberate use of a person's mental powers to do an action to achieve or satisfy a goal. Hence, the intention is frequently employed in relation to the outcomes of an act rather than the act itself. The Penal Code does not define intention. Words like voluntarily, willfully, deliberately, deliberate intention, with the purpose of, or knowingly, are also used to represent it. These expressions can be found in the IPC's various sections. They are 1. The word voluntarily is defined under Section 39 of the IPC. The Code provides that a person is said to cause an effect voluntarily when he causes it by means whereby he intended to cause it, or by means which, at the time of employing those means, he knew or had reason to believe to be likely to cause it. 2. Section 298 of IPC. In Section 298, the terms deliberate intention and premeditated intention are used. Section 298 provides that uttering words, etc., with deliberate intent to wound religious feelings. The Code provides that whoever, with the deliberate intention of wounding the religious feelings of any person, utters any word or makes any sound in the hearing of that person or makes any gesture in the sight of that person or places any object in the sight of that person, shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine, or with both. 3. Sections 285, 286, and 287 provides that, deliberately or negligently omitting to take reasonable care so as not to cause harm to human life in respect of possession of poisonous substance, fire, inflammable matter, and explosive substances, an offense. Section 285 provides for negligent conduct with respect to fire or combustible matter. The Code provides that, whoever does, with fire or any combustible matter, any act so rashly or negligently as to endanger human life, or to be likely to cause hurt or injury to any other person, or knowingly or negligently omits to take such order with any fire or any combustible matter in his possession as is sufficient to guard against any probable danger to human life from such fire or combustible matter, shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. Section 286 provides that negligent conduct with respect to explosive substance. The Code provides that, whoever does, with any explosive substance, any act so rashly or negligently as to endanger human life, or to be likely to cause hurt or injury to any other person, or knowingly or negligently omits to take such order with any explosive substance in his possession as is sufficient to guard against any probable danger to human life from that substance, shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. Section 287 provides that negligent conduct with respect to machinery. The Code provides that, whoever does, with any machinery, any act so rashly or negligently as to endanger human life or to be likely to cause hurt or injury to any other person, or knowingly or negligently omits to take such order with any machinery in his possession or under his care as is sufficient to guard against any probable danger to human life from such machinery, shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. 2. Recklessness. Let's see what recklessness is. Recklessness is regarded as a person's state of mind in which he foresees the prospective repercussions of his actions but does not intend or seek to bring them about. A person is said to be reckless when it comes to the consequences of his actions if he foresees the possibility of them happening but neither desires nor expects them to happen. Thus, when a person does an act with foresight of injury but without desire to cause harm to any person, the state of mind can be called recklessness. 3. Negligence. Negligence is a legal term that refers to a lack of care and caution that a rational person would have done in the given circumstances. Negligence is defined as failing to do something that a prudent and reasonable person would do or doing something that a prudent and reasonable person would not do based on the considerations that normally govern the conduct of human affairs. It is a man's state of mind when he pursues a path of action without considering the repercussions. In contrast to the concept of negligence in torts, it is not the basis of liability in general in crimes. Only in a few instances does the IPC, 1860 establish criminal liability based on negligence. For example, a man is accountable for negligence if his actions endanger the lives of others, such as in the case of rash and negligent driving, rash vessel navigation and so on. Let's see the difference between negligence and neglect. Neglect, unlike negligence, does not imply a particular state of mind, but rather describes a fact that could be the outcome of either a deliberate or negligent act. A man who knows his bike's brake is broken and fails to repair it and crashes onto a child on the road. The injury to the child is caused by his intentional neglect or recklessness in failing to repair the brake, rather than his negligence. Negligence means want of care. When a person who is bound to take care fails to take care of an ordinary prudent man, his mind is at fault and the faulty state of mind is known as negligence. Recklessness includes negligent conduct. 4. Knowledge. Knowledge refers to the personal information of a person who does an act. It is a state of mind of a person. The awareness of the act's repercussions is known as knowledge. It is a person's state of mind towards existent facts that he has personally observed or whose existence has been transmitted to him by others whose veracity he has no cause to dispute. The essence of knowledge is that it is subjective. Let's see the distinction between knowledge and intention. In many circumstances, intention and knowledge imply the same thing, and intention can be inferred from knowledge. Although the border between knowledge and intention is blurry, it is clear that they mean distinct things. Knowledge, in contrast to intention, denotes a state of mental realization in which the mind is a passive recipient of certain ideas or impressions that arise in it. Intention denotes a conscious state of mind in which mental faculties are summoned into action to achieve predetermined outcomes. Knowledge is predicated on a thorough understanding of the facts and situations, as well as the consequences of one's actions. 5. Motive. Motive is the emotion prompting the act. Love, compassion, fear, jealousy, hatred, perverted lust, desire for money, etc., are examples of emotion promoting us the act, and they constitute motive. Motive is the ulterior object of an act which prompted him to do an act. It is to be noted that the purity of motive or good motive will not convert an act which otherwise is criminal into one which is not punishable. That's all for this video. Click on the bell icon to get notified when we upload new videos. Subscribe for more videos. Visit our website for MCQ examinations and notes on this topic. Happy learning. A video from Law Aspirants Hub.